5 seconds. Start. There are two main grounds on which the learned solicitor general appearing on behalf of the appellant challenged the order of interim injunction full stop. The impugned order amounted in effect and substance to an order directing the appellant to pay the amounts of the pending bills of the respondent in respect of the other contracts, and since the question of payment of the amounts of such pending bills did not form the subject matter of the reference which was pending before the arbitrator, the learned judge had no jurisdiction to make such an order, and the impugned order was therefore outside the scope of his power and hence invalid. Full stop. It is not necessary that the sum of money must be due and payable to the purchaser. Full stop. It is enough if there is a claim even for damages. Full stop. Whenever there is such claim, the purchaser is given a right to recover it by appropriating any sum then due or which at any time thereafter may become due to the contractor under the contract or under any other contract. Full stop. The appellant was therefore entitled to recover the amount of its claim for damages against the respondent by appropriating the sums which subsequently became due to the respondent under other contracts, even though the claim for damages was contested by the respondent and was pending adjudication before the arbitrator. Full stop. An interim injunction could be granted to prevent the exercise of such right. Full stop. If interim injunction were to be granted in a case of this kind merely on the ground without anything more that the claim for damages is pending adjudication and until it is determined in favor of the purchaser, it should not be allowed to be recovered by the purchaser out of other sums due to the contractor. It would render the clause meaningless and the right to the purchaser under that clause would become false. Full stop. It would be open to the court even in such a case to grant interim injunction if it is satisfied that the claim for damages is prima facie not well founded and the balance of convenience requires that pending adjudication the purchaser should be restrained from effecting recovery of the claim for damages from out of other sums due to the contractor. Full stop. But here, admittedly, neither of these two factors was taken into consideration by the learned judges, and the order of interim injunction made by him